If you marry in community of property and later divorce, you may assume that you will automatically receive half of the joint estate. But will you? Hi, I'm Simon Dippenaar and I'm a family lawyer. When a marriage is in community of property, the marital estate is jointly held. In the event of divorce, assets are divided equally. However, there are exceptions to the rule. In some circumstances, according to the Divorce Act, and I quote, the court may make an order that the patrimonial benefits of the marriage be forfeited by one party in favor of the other, either wholly or in part, if the court, having regard to the duration of the marriage, the circumstances which gave rise to the breakdown thereof, and any substantial misconduct on the part of either of the parties, is satisfied that if the order for forfeiture is not made, the one party will, in relation to the other, be unduly benefited. Unquote. An example of this might be the marriage after a short acquaintance of a wealthy older person to a much younger spouse. During the marriage, the youthful partner has extramarital relationships and soon decides to file for divorce. It might be deemed an undue benefit if that person walks away with 50% of the older spouse's assets, and the court might make an order distributing the joint estate in different proportions. A case appeared before the Gauteng High Court recently in which a wife had been denied an equal share of the joint estate and divorce on the grounds that she unduly benefited. She appealed against the decision, and the appeal was actually upheld. The case raises some interesting points about the nature of the marital relationship and each spouse's contribution to it, as well as the legal implications of certain conduct. Now, what happened? The couple, we'll call them Mr. and Mrs. A, married in 1985. They had 3 children. During the marriage, Mr. A paid the bond on the marital home, and Mrs. A paid the utilities, grocery bills, and all the costs associated with raising the children, including school fees. Mrs. A left the marriage in 2007, but the couple did not divorce until 2018. Now, Mr. A claimed the marriage breakdown was a result of Mrs. A's abuse of alcohol and mismanagement of finances. During the marriage, Mr. A had engaged in extramarital affairs himself and had been abusive towards his wife. This was the real cause of her departure from the family home in 2007, the court found. After the couple separated, though, Mr. A cashed in his occupational pension and withdrew a lump sum of $500,000, placing the remainder in a living annuity. He bought 2 vehicles, paying for one of them with cash from the pension. He also paid off the remaining bond on the marital home. Now, bear in mind, Mr. and Mrs. A were not divorced at this point, and so these purchases were effectively made from the joint estate.